So in Chapter 9, we look at, in more detail, of those elements of capacity, legality, assent, and form. And specifically, we get into what happens when a minor gets in a contract and wants to get out or decides to stay in. We look at things like exculpatory clauses, situations where the consent to enter into a contract might be missing. We look at fraudulent misrepresentation. And finally, those situations where contracts have to be in writing to be enforceable. Remember last time we introduced that idea that one type of contract was a written contract, but not all contracts are in writing. Now we learn that some contracts do have to be in writing to be enforceable. So, remember capacity, one of the elements of a contract? Now this slide digs deeper into that and talks about the competency component of that. Remember, there was two parts to capacity. One was whether you're competent to enter into the contract. Anybody remember what the other part was?
If you got the mental.
Well, that relates to competence. What was the other part? Was it one that I said? It's not really that clear from the chapter, but I threw it in there. You should know it. You may see it. Anybody in here need a car? Maybe I'll go out over the weekend and buy you a car.
Voluntary.
Right, whether you're the right person to enter into contract for somebody else. Whether you have their permission, or maybe you're an agent. Otherwise, you don't have the capacity. Remember also, not everybody in a corporation has the capacity to bind the corporation to a contract. So there's two parts to capacity. One's competence, and the other is, are you the right person? All right, so now this digs into that first part of it, competence. And I think most people understand full competence. That means you understand what's going on around you, and you understand the contract you're entering into. And I think people understand no competence. You don't, right? You're not getting reality very well. It's this limited competence, I think, that causes some problems, where maybe you can function, but a question comes up as to whether you understood what you were getting into. Now, why is this so difficult? Well, one reason is because it's not usually an argument to say, I just didn't understand, right? Because you're presumed to be able to read and read it before you sign something. If you don't understand, ask questions. If you really don't understand, then don't do it. But this is getting at whether it's possible mentally for you to understand what you're doing. So we'll get into a little more detail about the things that affect that. One thing that the law says is that minors can enter into contracts. They have the capacity to do it. I don't agree with the second bullet up there. It's probably important for you to make a note of this, because later if you weren't here or didn't listen to the recording or weren't paying attention, it says a minor can enter into any contract an adult can. Well, that's not true. The point is they're trying to say just because you're a minor doesn't mean you're incapacitated. But can you guys think of a contract that a minor can't enter into?
Something that's got to do with breaking the law or...
Well, adults can't do that either, right?
I mean, like, say for instance, minors under 21.
Right, yeah. So some things that are legal for an adult to contract for, like consumption of alcohol, may not be for a minor or for purchasing it. Sure. And then you think of other cigarettes or other situations where it's lawful for an adult to contract, or my other class, or maybe it was you guys. Were we talking about gambling in here? Were you looking up gambling? Mm-hmm. Yeah, so that's another example. So anybody hear what happened to the Gun Lake Casino?
They had to close, like,
I heard they had the exit ramps.
all around,
Yeah.
because it was too packed.
Yeah.
They had to turn people away because they heard about it.
Oh, you were there? Huh? Awesome. Were the ramps closed down?
Yeah.
How'd you get there?
Well, we came from Gun Lake.
Oh, okay.
Parents live out in Meadowville, so
Okay.
we came and
Sorry about that.
It still was
Yeah.
probably an hour of waiting.
Just to get on, well, it's a dinky little road. You just,
Well, actually,
it is. It's not that big.
a lot bigger than it used to be.
Yeah.
I used to live over by towards Patterson,
Yeah.
132nd,
Right.
and they bought my house to make that road bigger.
Oh. Cool. So you're kind of paying it back. It's like, we need your house. Okay, give me money. And then you take the money back to the casino. Wow.
But, yeah.
All right.
I actually won.
Lawfully. But not if you're a minor. Back to our point here. So it says on the last bullet, a contract entered into by a minor that they can enter into, right? That's lawful for them to enter into, is voidable at the option of that minor, not the adult. It's not a defense for an adult to say later, oh, I entered into a contract with a minor, I want to get out of it. They're not being very cooperative. Then you shouldn't have done it in the first place. So it's voidable only at the option of the minor. So here's that word, DisAffirmance. So DisAffirmance is the exercising of the right to get out of the contract or to avoid the contract. And the thing I'd add to the slide is a little timeline. So here's 18, and let's say somebody contracts here. According to the slide, or what you read, when can the minor disaffirm the contract?
Anytime up until 18.
No.
Any reasonably after.
Right. So from here, when the contract is formed, definitely anytime they're below the age of 18, even at the age of 18, and for a what? A reasonable period of time. Well, you know, the book says that. But, you know, doesn't it depend? Like, unless there's a statute that says absolutely you have to exercise your right within 2 months, courts interpret what a reasonable period of time is. So then it says DisAffirmance, this exercising of the right to get out of the contract, can be either express or implied. Well, what would express be? Right. I want out in writing or orally. How would you imply that you no longer want to be in a contract? Right. By canceling, by taking back whatever it is, by not paying, right? What did you say?
That wasn't exactly what I
Oh,
meant.
okay.
But
Oh. Okay. But that's pretty much it. Just don't do what you're supposed to do. That would imply you don't want to do it. Bring the car back. Leave it sitting on the lot. So act in ways that are contrary to acting like you want to remain in the contract. Notice also that if you do disaffirm the contract, then you need to disaffirm the whole thing. You can't say, I'd like to keep the car, I just don't want to make the payments. Right? You got to get out of the whole obligation. So, here's where it gets a little tricky. You might be asking yourself, what does the minor have to do if they want to get out of it? It seems kind of unfair that they can just back out. In most states, underline, asterisk, whatever you need to do, minors only have to give back what they've got if they still got it. That's what that says. So think about it. You sell a minor a car, and they're the only person that contracts for the purchase of the car. Then during that period of time up there, they could bring it back in whatever condition they want to, including saying, well, it blew up. Right? Because it says, provided the goods are in the minor's possession or control, or I don't have it anymore. Yeah, everybody is always like, "Darn, wish I'd known that." I mean, in reality, knowing that minors have this right to change their mind and trash your stuff, are you going to contract with them alone? Probably not. That's the whole idea. And the idea is that the law puts the burden on the seller to confirm who the person is, to protect themselves, and to not take advantage of minors. Okay? My daughter, we went shopping this weekend, and she had some birthday money. And we went to the store. She's like, "I'll buy everything." She wanted to buy her brothers and sisters, she doesn't have any sisters, her brothers, toys and stuff in the store. I'm like, okay, you don't have that much money, right? Minors, they get a hold of money, they just want to, it burns a hole in their pocket. They just want to spend it on stuff. What's that?
Future politician.
Yes, just spending more money than she had. So that's kind of a bummer to think that they can keep what they have and then decide to get rid of it. And minors don't always take good care of stuff when they have it. An increasing number of states, the minor must restore the adult position held before the contract was made. So statutorily, a number of states are saying, okay, you can give it back, but you really need to return the adult to where they were before you did this to them. So put those things together. Even though a number of states are trying to fix that, a majority of states, in most states, it's still minor is preferred. Now, there are some situations where a minor can't disaffirm. But read this carefully. Generally, because it says exceptions to minor's right to disaffirm, and then it says misrepresentation of age. If you don't pay any attention to that, you might think if a minor misrepresents their age, then they cannot disaffirm a contract. But that's not what that says. That says generally they can get out even if they do misrepresent their age. Now usually the eyebrows go up. What do you mean? They get rewarded for lying? Hey, minors change their mind. Minors lie. They're irresponsible. Actually, I know adults like this too, but this is the way the law treats them. If you are going to contract with minors, then there's risk associated with that. And one is that they might not be totally honest because they really want whatever it is you're selling, so they'll say whatever they need to sell it. Somebody was pointing out a case to me where a nightclub got in trouble for letting minors in and selling to them, and then there was some kind of legal action about the minors maybe being responsible for the heavy fines that the nightclub got because of their misrepresentation of age. Like the theory is, we got criminally punished and fined for your lying to us about how old you were. And the law puts a pretty big burden on parties to verify the age. But at some point, and you don't have to admit if you have any experience with this, some minors do a pretty good job about lying about their age to the point where they commit fraud and tamper with things to make it appear they are old enough. That's why the second bullet there. A growing number of states prohibit disaffirmance and hold the minor liable if you can establish that the minor committed fraud against you when entering into the contract. But again, notice what it says. Generally, and then it says in a growing number of states. So, what's the risk here? The risk is if you sell to a minor, even if you don't know they're a minor, you still might be held responsible unless you do everything you can to verify how old they are. And then it's statutory. Yeah. Right. That's the most common way of misrepresentation of age. I mean, most sellers aren't going to say, how old are you? And somebody goes, I'm 18. Good enough for me, right? I mean, they're going to ask for something, at least some kind of statement, that they are. signed, whatever. But yeah, sometimes minors do that. They carry around fake IDs. So in that case, usually it's statutory. What does the law say? And that's why the second bullet. A number of states are creating new laws that say, well, if you go that far, there's really not much the seller can do about that. They believe they were contracting with an adult. All right, second bullet, contracts for necessaries. All right, here's the theory. The theory is that nobody would sell anything to a minor if they thought that minors could back out and not pay for it, including they would never give them food, clothing, or shelter. I mean, if there's this rule that they can decide not to pay you, then, it seems reasonable that you shouldn't sell them a car or mobile phone or whatever it is. But these type of things they really need. And so if you didn't have this exception, nobody would provide these things to minors. So notice the law is intended to protect minors. This protects minors. It lets them get food, clothing, shelters, things that are necessary for them to live, because the seller will give it to them knowing that somebody is going to be held responsible. Does that make sense? So one of the exceptions is if the contract, the subject of the contract is necessaries, defined as food, clothing, shelter, things that are necessary for the minor to live with, then they shouldn't be able to disaffirm the contract. Notice it says up there, contracts for food, clothing, and shelter may be disaffirmed by a minor who remains liable for the reasonable value of the goods or services. So they could decide to get out, but they're still going to be held responsible for what they use.
So reasonable value would be determined by a reasonable person or a judge?
Yeah. And you really could get into this. Like the court cases have said that necessaries depends on who you are. Like necessaries for a movie star kid is probably different than necessary for my kids. That part's subjective. Now, we're going to get into some exceptions to the exceptions, too. Insurance. Now, I had a student argue with me, well, insurance is necessary. The law requires it. Well, the law does require you to have insurance, but it doesn't make you drive. Right? Remember that from your parents? What did they tell you about driving? It was a what? Privilege. As a few years ago for me, but I still remember the lecture. Right? So it's a privilege to drive, so insurance, we need it to drive, but we don't have to drive. And therefore, if you contracted with a minor for insurance, then they could back out and not pay. Now again, realistically, how often do minors have their own insurance policies versus being on someone else's insurance? Not very. So again, these laws are to protect minors, and so you just don't do these kind of things in most cases. Loans. Loans, just giving minors money, right? Again, the law protects the minor. They're going to want to borrow as much money as they can. They don't know what they're doing. So the law says, well, you can, but then you can back out of it. So the seller or whoever the creditor is shouldn't do that. Notice the word seldom and exceptions. So generally, the law doesn't let you lend to minors without them backing out. In other words, if you do lend to them, they could say, I can't pay anymore. Unless the reason you give them the money is for necessaries. So if you heard what I said, I just said, loans are not necessaries unless the loan is for necessaries. Does that make sense? It's a little odd, but it's saying that maybe a minor needs food, clothing, and shelter, but they don't have the money for it, so they go borrow the money to buy that stuff. In that case, if that's why you gave it to the minor, which I guess we could go around and around about how you prove that the reason you gave them the loan was for those things, and they used it for those things. Yeah.
So would legally separated from parents?
Yeah, so I think there's a slide coming up here on emancipation, but the purpose of this law is for the law to protect minors and not take advantage of them. And if a minor goes out and says they don't want to have that protection anymore, they want to be treated as an adult, then the law will. So they won't be a minor, even though they're less than the age of majority. Then if they're emancipated, then the law is going to treat them like they're an adult in all ways, not just so they don't have to listen to what their parents say, but so they can go out and contract for the things they need to live on. That's a good question. That does come up. All right, ratification is the flip side of DisAffirmance. It occurs when a minor, on or after reaching the age of majority, indicates or expressly or impliedly an intention to become bound by a contract made as a minor. What's wrong with what I just read? When can a minor ratify a contract? They can't. It's a trick. If they're 18, they're not a minor. So I disagree a little bit with that. A adult can ratify a contract they entered into it as a minor once they reach the age of 18 or for a reasonable period of time. So just that. They can't ratify it back then, because then what could they do? Change their mind again, right? You know, they're minors. They do things like this. It's only once they reach the age of 18 and for a reasonable period of time after that that they could decide, I want to stay in it or I want to get out of it. And then after that, they're in it, right? If they act like they're in it and they stay in it, then they're in it. The law implies that they have ratified. You know me, on my 18th birthday, before I blew out the candles, I said, I hereby ratify all contracts I entered into as a minor, but you probably didn't do that, right? Probably just didn't even know, right? You're saying earlier, I wish I'd known. You just kept doing whatever it is you did. And the law presumed that you wanted to stay in any contract. Anybody have that situation? Mobile phone contract, car, something that they purchased and then after they're 18 they continued to pay for it? Cell phone, yeah. So, I remember back when I had my bag phone. You guys don't remember that, do you? Man, that was so cool. Big old zip bag thing you carry around in your car. That's cool. Yep. All right, so executed versus executory contracts. Remember that? Executed meant what? Yeah, everyone's done everything. Executory means at least one person hasn't done at least something, right? So how does that apply to minors? Well, what we were saying here, as a minor is in a contract, cell phone, car, it might be executory. They're making payments over time over it. So the question becomes, if they're still in a contract when they reach the age of majority, what happens to that contract? Well, unless they do something about it, they're going to be in it, right? They're going to impliedly ratify the contract. All right, and I understand why the author throws in the contract liability thing here. I don't know why it goes off in the tort liability. I guess people have questions about it, but sometimes parents want to know what liability they have for contracts that their minor children enter into. Maybe you don't worry about that so much. I'm getting a little concerned. But generally, parents don't have liability. If they're not on the contract, they don't know about it, and the kid comes home contracting for something, not their issue. That's why, in order to hold a parent liable, what do? You get cosign. You get them on the contract. Otherwise, they go, I didn't know about it. I didn't agree to it. I'm not bound by it. Since we talked about torts earlier, how does the law treat parents' liability in torts? Minors are certainly liable for their own torts. They go out and hit somebody or do something, they have their own liability. Usually, that doesn't automatically mean the parent's liable for those things. But there are some statutes that are more recent in nature that do try to hold parents liable for negligent things their kid did. Usually, they involve some kind of negligence on the parent's part. Like if you go into Dick's Sporting Goods and look at all the guns, there are signs here and there that says you're responsible for locking these things up and not letting your kids play with them. Makes sense? My kid, oh my goodness, my youngest, he can get into anything. It's unbelievable. Did I tell you about the SERP? Turned our heads for a second. He took a full bottle of SERP, ran all the way through the house with it. It soaked into the, deep carpet. It's in there. Good thing is you just wipe your pancake. I'm just only sorry I wasn't home for that one. All right. Intoxicated persons could lack the capacity to enter into a contract. If you remember when we talked about crimes, we said voluntary intoxication is rarely a defense. But here it can be. Whether you're forced to be intoxicated or you voluntarily did it to yourself, if you don't understand what you're doing, the law may let you out of it. Now, of course, later establishing that at the time you didn't know what you were doing, that can be a little hard. Right? Yes, does this relate to Friday? Or no? Okay. Yeah. Yeah, I don't think that's force. I mean, I suppose you can make some kind of argument that you were told you were going to lose your job if you didn't or something, but right, yeah. But in terms of a contract, it really doesn't matter. I mean, that's the point, is whether you feel like you lose your job or you go out and just do it. If you are, in fact, intoxicated and don't know what you're doing, the law will let you avoid a contract. It's just, like I said, it might be hard later to establish that.
There's a show on ABC, I forget what it's called, it's like Jim Belushi, where they try to sue like the casino, or this guy owed the casino like $13 million. Yeah. And they tried to get that taken away because they tried to claim coercion because they kept giving him drinks and he was completely plastered. And then they tried to hold his hand up to sign the contract or something because he was doing, I forget what they call it, vouchers or yeah, so he went into like millions of dollars in debt. I don't remember how it wound up though.
Well, if it was on TV, it must be. Was it The Defenders? Must be accurate. Right. So yeah, weren't we talking about that? The idea that they like to get you drunk at casinos, right? So that, and then what is the legal ramifications of that? Well, yeah, I mean, right. Well, that's the idea, is that in a criminal case, that doesn't work. So like say you're at the casino and you're intoxicated and the law lets them do that to you, but then later you get pulled over and you can't say, sorry, officer, I was too drunk to know that I shouldn't drive. That won't work. All right, so it might be voidable or valid. Notice it says voidable or valid. Voidable meaning a valid contract, but one you can back out of if you can establish that you didn't know what you were doing. Also notice the last part of this slide. Voidable means, and we spent a lot of time on talking about disaffirming, getting out of, but you could also stay in. You might wake up and go, hey, I didn't do too bad for myself. Right? It doesn't mean you have to get out of it. It means you have the option to get out of it. We're talking about extreme situations here, but 3 martini lunches happen. Right? People go out and they negotiate over drinks, and then later, I probably wouldn't have done that if I hadn't been under the influence. All right, so back to incompetence related to somebody's mental ability. Not being a minor, not being intoxicated, but some mental disease or defect. And this one's a little tricky. This one will get you. Let's use our timeline again. And we'll say this is the time you contract. The first rule is it doesn't matter what your capacity is before or after. What the law is concerned with is what your mental capacity is at the time you entered into a contract. That's what they're looking at. They want to know if you understood what you were doing. Right? So, now we'll throw in whether a court has determined you have capacity or not. So, according to that slide up there, if prior to entering into a contract, a court determines that you lack capacity, in other words, they appoint a guardian for you, then what is this contract afterwards? Void. You no longer have the capacity. This means that someone who sells to you without knowing this is out of luck. And you might say, that doesn't seem fair, if the person acts completely normal. Doesn't matter. Legally, it's been determined they don't have the capacity, and the only person you can deal with is the guardian. So look for that in a scenario. If you see a court determining somebody lacks competency, then any attempt for them to enter into a contract afterward is void. Now, let's say that the court determines that they lack capacity, but the question is about the contract they entered into before that. What kind of contract is that? Based on the first rule I gave you, that what matters is what your capacity is at the time you enter into contract. What's the guardian have to do to avoid that contract that was entered into before the court determined the person lacked capacity? Okay, I'm not telling you then. No guesses? What was rule number 1? What matters is the person's competency at the time, right? So, if a guardian, let's say the reason this person ended up in court and they determined that they didn't have the capacity is because they kept entering into a bunch of crazy contracts. I didn't mean that insensitively. Just not wise contracts. Like, if anybody's ever had an elderly relative who's buying all kinds of things that they don't need, aluminum siding for their brick house, or, a year's supply of dog food for the dog they don't have, whatever it is, right? At some point, somebody says, we need to do something about it. We need to protect them, right? So the guardian has to establish that back then, this person lacked the capacity to know what they're doing, right? We know what happens with any contract they try to enter into afterwards, but the question back here is, what is their capacity? And if they lack the capacity to enter into this contract, that contract is what? Yes, voidable. Meaning the guardian could elect to stay in it or get out of it. Right? Yeah?
So one could prove that someone was concussed when they made a contract with their possibly make it void?
Sure. Yeah, I mean, the reason that you lacked mental competence could be because of a head injury or, some temporary thing. Right, notice the bottom there, it talks about a lucid interval. There are people who have mental competency issues. Maybe they're medicated. Maybe there's times when they're fine, times when they're not. All right, so let's say the court's not involved. And at the time the person enters into the contract, it's determined that they have competency. What kind of contract is that? The last one. Valid, right? What that last one means is perhaps they're incompetent here, incompetent over here, but right here, if they're competent and no court's made any determination about them, then they're stuck with that valid contract. So hopefully you've got some little timelines in your note there. Should help.
Courts make the decision later that it wasn't unconscionable.
That was the...
It wasn't unconscionable, I'm sorry.
So you're saying
Like they made
contract, and then later, that's supposed to say contract, later.
they filed for SSI.
And so after that, we know this is void. Now, what's your question? What about this one? Okay. Right, we were just going through that. My timeline was a little over here.
So, basically, they entered in contract, and they seen that they had capacity later on. They filed for
Right.
security for mental disorder or some type of mental disorder. Got approved, and then said that later on they want to be in that contract no more because they lack capacity.
Right. So let's say there's some determination that they lack capacity. That determination is what their capacity is at this point in time. You're saying, what if there's a contract going on? That's a little different question. The contract back here, when they may or may not be competent. So let's say they are, but now at some point they're not anymore. Well then, shouldn't they be able to avoid that? They're unable to perform under the contract. Yeah.
Like if they like buy a car when they're not competent, and like really minor, they have to return it like a condition.
Yeah, I think that that's mostly statutory in terms of whether you have a right to do that and return it and what kind of condition it is. I guess the answer is it depends. Like their competency may affect the condition of whatever it is that they have. Like what if you lease a home and then you fill it with 100 cats? Right? I mean, this happens. You hear about it in the news. And then later you want out, right? You want out of your lease or whatever. And then whatever you're going to give back is not in the same condition as when you leased it. And it's due largely to your lack of competency. So the court would have to look at that to determine what your responsibility is to make the landlord whole. Usually at that point you don't have a whole lot of assets. But maybe you do. I mean, suppose you could have won a lot at the casino at Gun Lake and then spent it all on cat food. All right, yeah. So whether you're competent at the time and whether a court is determined that is important. All right, legality, another element of a contract. We've already given you the straight, if it violates a criminal statute, you can't do it example. Like a contract to kill me is not a contract because that would be unlawful. Contracts that are contrary to statute are usually illegal, and there are some other examples up there. So usury, anybody know what usury is? Right. Yeah, so charging above the legal interest rate. It's kind of, again, that same theory that protect consumers from charging them too much interest. And so if there's a contract to do what is illegal to do, then that may not be an enforceable contract. Or gambling. Some gambling is illegal. We've talked about situations where it's lawful. I would say most of it that people do is illegal. Like people don't always go to casinos. They do office pools, right? And they do things online. Yes. Yes. Yes, it's unless the government's doing it or has sanctioned it, it is against the law to do. Right? Any gambling is illegal. What's that? Yeah, you know I'm recording, right?
What about like fantasy football?
Right. Same thing. Same thing. Gambling over fantasy football is illegal. Unless there's a law that permits it. And when is the law going to permit you to gamble? When the state's going to benefit from it. I mean, think about the lottery. Why is it that say gambling's a big no-no, but the state can collect all this money and use it for education and for other things? I agree. Yeah, exactly. Licensing statute. So, if you don't have the right license, you can't contract to do certain things. Like, I have to have a license to practice law in order to provide legal advice. And if I contracted with you to provide you legal advice and wanted you to pay me and I wasn't properly licensed, that would be against the law and it would be an unenforceable contract. Now there is an exception to this that's not on the slide, but I'm going to say it. It depends on the purpose of the licensing statute. If the licensing statute is designed to protect people, then you got to have the license or you won't be able to enforce the contract. I just gave you an example, right? It's good to have lawyers licensed and have oversight of them, or they'll take advantage of people. Other things don't always require. They're more generate revenue for the state, like go get this license, pay a fee. But they're not really all around having somebody have a license with an exam that protects the public. In Michigan, you have to have a license to be a residential alteration contractor. Anybody know what that is? You remodel things. Fix somebody's basement, fix somebody's roof. You have to have a license to do that. And if you're not, and you do the work, and somebody doesn't pay you, if you sue them to try to recover what you're owed, the first thing you have to put in the complaint is, my license number is. And if you can't sue them. Yeah.
Didn't that happen here a couple of years ago, that doctor or whatever?
Right. Yeah, there's examples of this being used the flip way too, and that is that people know this law, and if this is what I think you're talking about, take advantage of people who aren't properly licensed and then not want to pay them. Right. And then later they try to sue you, you're like, well, you're not able to. The statute says you can't.
$100,000, I mean, it's a huge amount of money.
Right. So, I mean, part of the question comes down to whether you know at the time you're contracting with somebody that they're properly licensed to contract. They tell you they are and they're not. Like they could easily put down that they have a license number and it not be an accurate license number.
Can you search that?
Sure. Yeah, you can check a database with the state and see who's properly licensed. Even me. You guys want to go out and find out whether I'm properly licensed? Yeah.
So say for instance somebody, I don't know, was doing catering. They was doing food,
Catering, yes.
banquet catering, and they had a client that they wanted to do a catering job for, and they did the catering job, but they didn't have any license, so they don't have to pay them. Right?
I don't know.
Or
I don't know. I don't know what the licensing requirements are around catering.
well, I know you gotta be certified, and,
Easy for you to say.
And,
Serve Safe certified?
Serve
Serve Safe.
Yeah, and I think that's about it.
Yeah, I would think any license related to health or safety or something like that,
Right.
you'd need to have it.
Right.
And it would be difficult to then go back later and take advantage of the fact you didn't have it. But I don't know specifically in the catering
I was just
business.
saying for all categories, like you said, you gotta start saying what my license number is.
No, I'm saying in that particular case, it's right in the statute
Right.
that if you don't have this license, you will not be able to plead it in a complaint in court. Because, if you go to court, what happens when you go to court and you lie and say you have a license and here's the license number? Yeah, you're in big trouble. So, yeah, that's not true of every licensing statute. That just happens to be the case with that one. And it might be with other ones. I don't know. Good question. All right, so going more along the business lines, it's possible that certain contracts might actually be deemed to be illegal because they restrain trade. Because acts that are anti-competitive might violate anti-competition laws or antitrust laws. And so in the practical way, what does that mean to you? Has anybody ever heard or been involved in an agreement with their employer not to compete against them? Either while they're employed with them or afterwards? So that's an agreement that restrains your ability to go out and get employment elsewhere or to work in a way you want to. Yeah.
For an example of that, I work for a financial institution, and we are not allowed to work for another financial institution or an accounting firm or real estate, anything like that, where we could benefit from both sides.
Yeah, so that is true while you're employed, and I bet even after you leave,
Yeah,
there's some agreement regarding the clients that you have.
we can't take clients.
Yeah.
That we've met.
I got a question for you. You can't marry nobody. What if you marry somebody? You know what I'm saying?
What do you mean?
Like, say for instance, you marry somebody.
Who works someplace else that's competition. Well, I think most agreements that restrain your ability to marry would be illegal,
Exactly.
right? Or any, maybe they say, well, you agreed contractually not to marry somebody who works for a competitor. That doesn't seem like that would be very enforceable. But maybe this is more to your question. If you then, in your marriage, share information that you are restricted from sharing it, yeah, I think you could be in trouble for that. Yeah.
I've heard the no-compete clause if you got, fired from your job,
Mm-hmm.
and then would that still hold up? It would prevent you from getting a job.
Oh, yeah, so,
If it's your own skills.
we're talking about the situation where you've got great skills and you're employed and you decide to either do some moonlighting or leave and go somewhere else. What happens if they fire you and then you want to go work somewhere else? I mean, there's some big ones in the news lately where, in the tech world, where somebody was the CEO of one company and they canned them, and then they turn around and, because they're a valuable commodity, someone else wants to use them. And then the old company says, whoa, 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 whoa. You're our direct competitor. If you hire them, then they're going to know all our secrets. And they don't like us because we fired them. And then that tech company ends up suing their former employee after firing them, making the argument that they entered into some type of agreement where they wouldn't go to a competitor or they wouldn't share that information. There are some states that have passed laws that restrict the ability to do that to people. Like California is big on not allowing a lot of this because it restrains people's ability to, if they've lost their job somehow, go get employment somewhere else. So you'd have to know what the law is. I actually, before I was an attorney, was a financial planner. And I had that, exact situation. I could not sell or work for anybody else. And when I left, I had to be very careful about how I communicated that I was leaving. If I sent a letter out while I was still employed to all my clients that said, hey, I'm leaving, then later, when I end up having those people working with me, maybe even in direct competition with my former employer, what are they going to say? I stole their clients. So you have to be real careful about it. But the point here is that those kind of agreements go on all the time. And the law usually allows them unless they're unreasonable. And really, the courts look at two things. They look at how long the restraint is for and how far. In other words, if you leave employment and you go to work for a competitor, agreements that say something like, you can't compete against us in a year, usually that's enforceable. Or in this geographic area. But if you say forever in the whole universe, that's a little too broad. So a lot of court cases are all about what's too broad. Because it could be like tri-state region for 20 years. And you've got to look at what other court cases were decided and whether it's too far or too long. All right, unconscionable contracts. I skipped a slide there, but this pretty much describes that. Unconscionable means it shocks the conscience of the court. It's kind of a catch-all. It's kind of a catch-all that even if the parties agreed to it, the court could say, this is shocking, I'm just not going to enforce it. Right? It's just so unfair or one-sided, we can't see doing our job right by enforcing this contract. And so there's two different kinds of unconscionability, procedural and substantive. Procedural meaning the way that the contract was entered into was too unfair or one-sided. So you look over there on the left, on the bottom, you get some ideas of what that scenario might look like. Really fine print, extremely difficult language to understand. The person was made to sign without giving adequate time to read anything. Or maybe significant disparity in bargaining power between the seller and the buyer. Now, let me just tell you, most of the time this isn't going to work. It's not going to work to say, poor little me consumer went into big car dealer who's a zillionaire, and they only gave me a few minutes before the store closed to agree to the deal. Most of the time the court's going to say, well, you could have still walked out. You did it. Your problem. But the court always reserves this right to say, wow, this one's really unfair. It's got all the factors aligned here. So there was a case where an elderly lady ended up paying 3 times the value of her refrigerator. And when the court found out about that, they said, you've paid enough already, refrigerator's yours, you don't have to make the rest of the payments. But even that case is an exception. I mean, think of rent to own. Think of how many people pay way more for something than they should have. The court usually says, your choice. You want to do that, go right ahead. And the person might say, well, I was forced to. I really couldn't buy it any other way. I'm stuck with this option. So it's one of those things the court kind of holds back and uses if it needs to. All right, over on the right, substantive unconscionability, it says, when a contract on its own, its terms are overly harsh or oppressive. So not the way somebody was forced into the contract, but the contract itself is just so one-sided the court won't enforce it. And it, it talks about, in the end, if the party doesn't end up getting what they bargained for, or leave them any remedies at all when the other party breaches the contract. What if you agreed to, hey, if I breach the contract, you can sue me and recover, and I agree in advance to pay a big amount of money, but if you blatantly breach the contract, I promise not to sue you for anything. And the court might say, oh, that's unfair. Yeah.
Is that kind of like how they had to change the new credit card bills to show you if you just paid the least amount, how much you paid?
I think a lot of those laws relate to court decisions where the court said, this is just unfair or unconscionable. So even when you think back to some of the credit protection acts we'll talk about disclosing the annual percentage rate and how much you pay over the term of the loan, all those things go back to court cases where the court just said, it's unfair for you to quote interest on a bi-daily basis or something. You gotta make it the same for everybody. You can't make it so difficult to understand. Yeah. All right. Exculpatory clauses. Exculpatory clauses are clauses that say we don't want to have liability if something goes wrong. So you probably have seen them. Check your coat here, we're not responsible for what's inside. Park your car here, but if something happens to it, we're not responsible for it. Pay us to go through the car wash, something happens to your mirrors or whatever, we're not responsible. So those type of things. The court, if you freely do that, the court will often enforce it, but if it goes too far and says the other party isn't liable even if they're the one that's negligent and causes the harm. Like what if you're going through the car wash and there's a sign that says, put down your antenna, but the car wash chews up your car? That might be a little extreme. Right? Did I tell you about that? I had a friend who his Jeep got demolished.
In the car wash?
Well, kind of. He took it to this fancy car wash where they take your car through, and you sit and watch it, and then at the other end they buff it out and ask you for a big tip. So he gives the guy the car, and the guy starts to go through the car wash, and all of a sudden he sees his car accelerate, launch into the parking lot next door, smash into some cars. It bounced off a couple of concrete barriers on the way. He said the bad part was when he went over there to see what was going on, some of the employees came over and started buffing out his Jeep like maybe he wouldn't notice. And then they said the worst part was on the way back, one of the guys said, yeah, that's the reason they put the concrete barriers there, because the same employee did it a month ago. Apparently the employee, who was not the best driver, kept mistaking the brake for the accelerator and panicked and jammed the gas and shot it. So there's a sign there that says we're not responsible for damage that happens to your vehicle, but they can't exculpate themselves from liability for their own negligence for that type of stuff.
But they didn't fire him the first time it happened?
I know. Not too bright. Which is, when we talk about employment law, and when we talked about tort law, what do you do when your employees mess up? You get rid of them, because if you don't, then later it comes back to haunt you, and then somebody not only argues they were damaged, but they argued you had a chance to not have this happen, and you let it happen again. So, yeah, he was not happy. We had a phone conference, and he tells me the story, and he had to take a bus home because his vehicle was totaled. I'm like, I'm never giving my car to anybody else to wash.
I wonder what lawyer you called.
I think that was a slam dunk case. All right. So this slide goes in a whole bunch of examples. I'm going to summarize it for you. Generally, what we've said is if a contract calls for somebody to do something that's legal, the contract's void. No contract, right? Well, that's a nice, easy, clean way of looking at it. But what happens if you're in a contract and then as a result something comes out that part of the contract is illegal? Like maybe you're getting the benefit of your bargain and you've paid a lot for your car and then you find out that you've been charged an unlawful fee or something. Does that mean the contract is of no effect and you have to give back your car? And they get to keep all your payments? That wouldn't be fair. So this is all about the other remedies the court can grant if it feels that the contract situation involves something that's illegal. Generally, what it looks at is there any way we can keep the legal part and get rid of the illegal part? So in the interest situation, what could they do besides just saying there's no contract? Drop it, right? To what is lawful and not charge. So the court has that flexibility. Or it could, if it's multiple installment contracts or something, it could sever the lawful part from the illegal part. Or it might, let's say that fraud was committed against you to get you into a contract, but the contract turns out to be favorable to you, and you've put a lot of effort and money and time into it. The court might allow you to remain in the contract and take advantage of the party who was fraudulent in getting you to enter into the contract. So there are other ways a court can deal with the effect of illegality other than just say there isn't a contract. All right, mistake. Remember bilateral and unilateral? Bi meant two. Now it means two what? Mistakes. Right? So, general rule, if both parties are mistaken about a material fact in a contract, then either one of them could back out. Can you think of a scenario where two parties agree to something and it turns out not to be true? They both were mistaken about it? What's that? No, we're not talking about marriage. This is where somebody emails me and says, somebody said something funny in your class, but I couldn't hear what it was. Make sure you repeat those things. What if you contract for an animal that turns out to be dead? No offense to animals or people who love animals. But you contract to purchase an animal, and at the time you do, it's a good deal for you because you're getting the animal and the person who's getting your money. But then when you go to complete the deal, it turns out the animal you contracted for is dead. You should, right? You should be able to get your money back. They shouldn't be obligated to deliver a live animal they no longer have. You both should be able to back out because you had a mistaken belief about the value of the animal because it's worth different now. Unless it's supposed to be dead, right? I mean, if it's steaks, that's different than if it's something else. The general rule with a unilateral mistake, which means only one of the parties is mistaken, is they're stuck with it. So if you contract to buy a painting and you believe it's worth $10,000, and after you buy it, it turns out it's not, you've assumed the risk that it is. And can you go back to the car dealer and say, you know what, I think I paid too much for this car. I think I could have got it cheaper somewhere else? I mean, you could try, but they're probably going to laugh. Yeah.
Does that relate to a friend of mine who supposedly bought a car on Live, and it didn't turn out to be a car because the other party knew they weren't selling a car, but she didn't know they weren't selling a car. So
Say that again?
One party mistake.
The other party, oh yeah, we're going to get to exceptions. It's right up there. Other party knew or should have known the mistake was made. So let's say you sell something to somebody and they're under mistaken belief it's a car when it's not really. You know it's really not a car. You can't take advantage of that. You can't go, ha ha, it's a unilateral mistake. You thought it was a car. It wasn't. What was it?
It was supposedly some.
Was it like a picture of another car that they didn't actually have for sale or something?
Right.
It sounds
They
more.
made up some big stories.
Yeah, sounds like fraud. I'm not saying that it is, but I'm just saying that from what you describe, you can't trick somebody into a contract and then claim they made a mistake about it. There's one I just saw on the news, Walmart getting sued over an iPad. I don't know if you saw this or not, but apparently this person comes into Walmart, wants their money back because they have an iPad that is fake. It's like partly paper. Like, like you see the display models. It was a display model. So they paid full value for an iPad and got a fake iPad. Now they're bringing it back and want their money back. And Walmart is saying, we're not paying you back. We don't know how you got a hold of this, but we didn't sell it to you. They do. So now on one aspect it might be, oops, we goofed. We packaged the floor model in the box and sold it to you. And the other party says, oops, I goofed. I bought what I thought was an iPad, turned out not to be. That'd be mutual mistake, right? They're making the argument, oh, no, not our mistake. We sold you a real iPad. We don't know how you got that one, but that's your problem. It'd be interesting to see how that one turns out. Wouldn't that suck? You're like, you get home, you're like, it's not really working. Wait, it's made of paper.
Well, they could have got that paper thing somewhere else.
That's what Walmart's saying.
Right.
They're saying that basically they're trying to get more for, they already have their iPad and they're trying to get more. That'll be an interesting case. So the general rule is only one party is mistaken, then they shouldn't be able to back out unless, then there's two exceptions up there. One is when the other party knows you're making the mistake and lets you make it. Like what if the person's like, haha, you're buying a fake iPad, but I'm going to let you do it. That they shouldn't be able to take advantage of that. And then the second one, if it's a typo, which is kind of a tough one, it's like you and I agree to buy my Jeep for $10,000. And then I type it up, and when I type 1,000. Whose mistake is that? Mine. The argument is that's a unilateral mistake because only I made it. Right? But then later, you start sending me payments. And you send me payments which are 1/10 of what I'm expecting, right? I'm like, what are you doing? You owe me whatever. I'm like, you say, well, look at the contract. You made a mistake. It's only 1,000. Often the court will say, well, that's just a typo error. You shouldn't be excused from your obligations as a result of that. Notice that's different than like an estimate that's too low. Like if a builder can't say, we have a contract, and then later go, you know what? I was a little low on my materials. I'd like to charge you more. That's not the type of mistake we're talking about. What's that? Yeah, right. Well, but then once you lock into the contract, all estimates are gone, and that's what you're doing it for. All right, so a mistake of value, like I think it's worth this amount of money. Too bad, your problem. That contract's going to be enforceable. We gave you the two exceptions there. Bilateral mistake, general rule is that either party could back out if it's a material fact. Fraudulent misrepresentation. Fraudulent misrepresentation. Somebody intentionally tells you something to get you to enter into a contract with them that turns out not to be true, and they knew it. That's different than somebody telling you something that's not true but not knowing that it's not true. So you go to buy a car and the odometer's been rolled back. Hi.
Hi, Kira. How are you?
I am good.
Well, I'm gonna make it better.
This is awesome. I'm live and being recorded, so unbelievably I'm getting handed a flower in class. Thank you. Oh, thank you. That's very sweet. Awesome. See, what was I saying? None of you got me a card, so they came through and got me a flower. Thank you. All right. Where was it? Give a flower to me and I'm just totally distracted. What were you talking about? I don't know. I wasn't listening. This is awkward. What? Yes, fraudulent. Yeah, good. It's at the top of the slide. Yeah, so somebody comes in and they want to buy a car and the salesperson says, it's got this many miles. Doesn't it matter whether they knew the odometer had been rolled back or not? Like if they rolled it back, then they know. But what if they're told something that turns out not to be true, they didn't know it? So if it's fraudulent misrepresentation, then the other party should be able to avoid the contract. All right, undue influence versus duress. These are different. Undue influence is about somebody taking advantage of a special trust relationship. So think guardian ward, attorney client, CPA client, those type of things. Like you use your power over somebody to make them do something they don't want to do. That was a great example. Different than duress. Duress is about forcing somebody physically to do something, either by making them do it or threatening them, right? So point a gun at someone's head and say, sign that contract or else. That's duress. Notice the last bullet, economic needs not enough. It's not enough to say, do this deal by 5 o'clock or no deal. That's not the type of stress we're talking about. Talking about do it by 5 or I'll kill you. That'd be enough. Yes?
I had a statement because I was in a position where in a duress position, and somebody had a gun to my head and they was trying to make me do something.
Not contractually, though.
Huh?
Not a contractual issue, though. They weren't pointing a gun at your head and making you sign a contract.
Right.
Okay, then that doesn't really relate to what we're talking about, right?
Well, technically, was I under duress?
Well,
And they were trying to make me sign something?
not a contract? Yeah, I mean, I wouldn't begin to offer an opinion about whether you were under duress or not based on what you described to me.
I was saying because I was in this position before.
Mm.
You see what I'm saying?
But not contractually, which is what
Contractually, what do you mean by that?
I mean that we're talking about contracts. And so if the scenario you're giving me is somebody pointing a gun at your head and making you enter into a contract, that would be an example of what we're talking about.
They was trying to make me sign something to get
Something.
make me.
But you said it wasn't a contract.
Well, it was held in court to let somebody else get released out of prison.
Yeah, doesn't sound like a contract from what you described.
I was just making sure.
Okay. Moving on. Statute of frauds. Remember when I said earlier some contracts have to be in writing to be enforceable? The statute of frauds is statutory law that says these type of contracts need to be enforceable. And there's some other slides on this, but this slide is a good summary of what those are. Contracts for the sale of goods priced at $500 or more. Basically, if it's a major ticket item, then it ought to be in writing so people know what the terms of the contract are. Now, you might say, but I know of a contract that's worth more and it's not. You might. We're just saying the statute of frauds says these kind of contracts need to be in writing to be enforceable. The second one, contracts involving interest in land. Well, it makes sense. How else are you going to know who has title, what's going on here, unless those contracts are put into writing. The next one, contracts that cannot be performed within 1 year. This one's a trick. I'm warning you. It says contracts that cannot be performed within a year. So let's say I contract to have a hole dug on my property by March 1st, 2012. Does that contract need to be in writing to be enforceable?
Yes.
Because
Why?
it can be performed.
It can be performed within a year. What if it said on then it's got to be in writing because it can't be performed within a year. It has to be dug on that date. Now, why in the world would I have a contract that says I want a hole dug on that date more than a year from now? Exactly. I'm not killing the person to put in the hole until later. No. This actually happened to me. I didn't own the property. You don't want a contract to have your hole on someone else's land, right? You want to wait until it's yours. Because if you dig it and then you fill it with money, which is what I did, then if the deal doesn't go through, someone else has got your hole with a bunch of money in it. Right, exactly. Thank you very much. Okay. All right. Contracts containing collateral promises. No one talks like that. Anybody know what a collateral promise to answer for debt of another is called? You mentioned it already in class today. Co-signing. That's what that is. And it really, when you think of it that way, it makes a lot of sense. Co-signatures should be in writing. Right? If you're co-signing, you're signing. Why? Because it just makes sense. If you don't, and then later someone comes looking at you to pay for someone else's debt, and it's not on the contract, what do you say? Why are you trying to hold me responsible for someone else's contract? So it should be in writing. Unless the reason that you agreed orally to pay someone else's debt is because it benefits you. That is the main purpose rule. Anybody know what page that's on? Anybody following along in the book? Where it talks about the collateral promises and 259? Okay. No, the main purpose rule. Yes, collateral promises, 256, and then the main purpose rule, which is underneath collateral promises. Yeah, so top of 257. Okay, an exception, yep. So look at 257. All right, so there's a bunch of exceptions up there. Most of those have to do with, the idea is that you need a writing to prove that there is an agreement, but those exceptions have to do with other proof that there must have been an agreement. Like, why would you produce customized goods for somebody if they didn't ask for it? Or why is it that you delivered the goods and they paid for the part of the goods if there wasn't any type of contract? All right, so those are some of the exceptions. All right, the writing requirement. Contracts are required to be in writing under the statute of frauds, but pretty much anything that's signed by the party you want to enforce it against is enough. So a memo with somebody's signature on it, a check with the memo filled out for a certain agreement or something like that could be enough. A napkin, whatever it is, as long as it has the terms of the agreement and it's signed by the party you want to enforce it against, that's enough. All right. I feel like I've lost your attention ever since the gal come in with a flower for me. So let's go down to the last slide here that really drives home that point of what a writing has to be. Could be a written contract, sure. Could be a memo. It could be most anything except, look at the bottom there, only requires the essential terms, identify who the parties are, and signed by whoever you're trying to enforce it against, and the signature could even be an e-signature. All those things are good enough. Okay? Any questions? Alrighty. Happy Valentine's Day. I'll see you Wednesday or I won't.